So Miss Williams, give me 1 second. So I did enter a default judgment on February 2nd. Let's see. Where, Miss Davis, I don't even see the motion. I must have seen the motion because I reviewed it yesterday.
Well, hold on just a second.
Oh, there it is. I see it. Okay. So it was filed actually before the default judgment was entered. How is that possible? Oh, because the hearing was before.
Hearing for
Okay, so the hearing was on the 28th. And then you filed this motion to set aside. Comes now. When you filed your answer, Miss Williams, how did you file it?
The online
Okay,
system.
okay. And Miss Davis, when did we mail the hearing notice?
it was mailed on January 21st.
Okay, and that's the same day it was postmarked.
Mm.
And the hearing was on the 28th?
Correct.
Okay, thank you, Miss Davis. So the address that we mailed it to, Miss Williams, was that a P.O. box or was that your house?
That's the primary residence address. There are often issues with the mail delivery system there, which is why I also retain a PO box.
Okay.
And I was not familiar with how the process works, so I didn't know where to expect the response, which is why the day of the original hearing, I checked online because I know that that would be the best way to see what was going on. And that's when I realized I had missed the court date and immediately contacted the clerk of court to receive direction on how to move forward.
So I'm sorry. So say again, it was mailed to your house, the hearing notice?
Yes.
And when did it arrive at your house?
I'm not sure when it arrived, but I didn't actually physically have it from my mailbox until the actual day of like the afternoon around 4 or 5 p.m. of the same day of the original hearing.
And why did you not check your mailbox before then?
My mail is supposed to be forwarded to the PO box, but for some reason, sometimes I still get my mail there, sometimes I don't. I still get mail from previous tenants. And just because of all of that lack of clarity is why I rely on the PO box.
When you filed your answer, you filed it under, did you ever enter a change of address or anything with the court when you filed your answer?
Not until I asked for the removal of the default judgment before it was actually entered.
Okay. And are you still living in the property?
Mhm.
Do you want to remain in the property?
I would like to. I attempted to negotiate with the attorney, but he preferred to be here
I
on
didn't
trial.
prefer it. I didn't prefer it. And I did make an offer.
All right, Mr. Hodges, I understand there just wasn't a meeting of the minds. That's fine. We don't need to get
Okay.
defensive. Okay, so so is there anything else you want me to know? We're just focused right now on, the fact that you missed the hearing and a default judgment was entered. And it looks like you filed your motion to set aside the day after, right?
Yes, and I uploaded evidence with my filing for that proves the ongoing mail issues with the apartment complex, as well as the weather-related barrier, as well as the death in my family that prevented me from addressing the issue
Well, you filed your
immediately.
answer on time. I mean, when were you out of town?
Because of the weather issues and the lack of travel arrangements secured by my family, I wasn't actually able to
Mhm.
attend the funeral in Chicago like I had originally planned.
So you were still here in
Yeah,
town
I was
that whole
I
week.
was I was preparing to travel, but my travel arrangements were not secured by my family like they were supposed to be. And I wasn't informed until the last minute.
All right. What do you have to say, Mr. Hodges, in response to her motion to set aside the default judgment?
It remains that it very well could have been in her mailbox, and she made the choice to check it when she made it. Maybe for good reason, and maybe the forwarding issue is something attributable to the post office, but at the same time, it was her choice to check her mail when she did.
Ms. Williams, did you check your mailbox at all between January 21st and January 28th in the morning?
No, because I'm not supposed to be receiving mail in that box at all in the first place.
Did
My
you go
mail,
to the post office to check your post office box between those 2 days?
yes, I check my mail weekly.
Weekly?
Well, I'm a single parent and a teacher, so I on Saturday mornings I go to the mailbox, the PO box at the post office location to collect the mail for the week, and then
So the 21st was a Wednesday. It was mailed on the 21st. Did you check your mailbox on the 24th at the PO box?
that was the weather. That was the week of the weather that made the roads icy and unsafe to drive.
Okay.
And I didn't return to work until the following Wednesday. Schools opened on the following Tuesday, but then the following like my neighborhood was still icy, so I didn't go to back to work on that Tuesday, and I didn't take my child to school that following Tuesday. That Wednesday was when we both returned to work in school, and then that following Saturday was when I checked the mail.
All right. Anything else you want me to know, Mr. Hodges?
Nothing further.
Give me 1 second. I want to look something up real quick.
Your Honor, I also uploaded the notifications from the school district from my child's school about the schools being closed due to the weather, in case that verification needs to be reviewed.
I mean, I was here too. I'm familiar with the weather for sure. So I'm looking at 9/11/60, which is the section of the Civil Practice Act that provides relief from judgments. So I have to find that there's fraud, accident, or mistake of the plaintiff unmixed with the negligence or fault of the moving party. So that would be you, Miss Williams. So I don't find that there was any fraud, accident, or mistake on the part of the plaintiff, or the court in this case. And sometimes we do send things out late, and that happens. But I do think that there has been, it's really on the line for me. So in the interest of allowing cases to be heard on the merits, I'm going to go ahead and grant the motion to set aside the default judgment.
Thank you. I appreciate it.
So I'm going to give you guys an opportunity to talk again, and then see if you can work something else out or if we need to set it for a trial. Okay?
I appreciate it, Your Honor.
All right. Court is in recess. Hello. All right.
Hi, Your Honor. This number 7's gonna have to be reset for a hearing.
Okay. All right, Miss Davis, are you thinking in person for a trial?
Yes.
Okay. So Miss Davis, what are we looking at?
Oh, just a second for me.
And we will ask for December rent to be paid to court.
Your Honor, December rent and January rent have already been tendered via certified mail and confirmed as received on January 3rd by USPS.
Well, I have a witness. I have a witness that can jump on and
I uploaded the
and
evidence
oppose
in
it.
my counterclaim and my answer.
Well, we probably shouldn't have the hearing right now, Your Honor.
No, but we
Reset.
have to I have to make a decision about your request for rent into court.
Okay.
Is there any allegation that rent for February has been paid in?
No, I retained that payment because of the eviction proceedings.
Okay. So, what is the base monthly rent?
They filed for 1415, so we'll go with that.
And Miss Williams, what do you think the base monthly rent is?
I agree. It's
1450.
1450. Yes.
Okay. Okay. So at the very least, I'm going to order that you pay 1450 for February rent. It's going to be paid into the registry of court. Usually I give folks a couple
I
of
can
days.
pay it today. I can
Oh,
pay it today via money order.
Okay, hold on. Give me a second. Miss
Okay,
Davis, what are we looking at for the reset date?
Monday, March 2nd
Okay.
at 9 a.m. in courtroom 1200C.
Okay. Does that work for both of y'all?
That's the
yeah.
next available date.
That's the next available date.
Can you please repeat the courtroom number?
1200C. And
I'm
you will.
sorry. I do apologize.
Mm,
I was looking at a different March 23rd.
wait.
I'm sorry, February 23rd. Please excuse me.
Okay. All right. So February 23rd, that's a Monday. Are you sure?
Yes,
1200C?
yes.
Okay. So 223, 9 a.m. in 1200C. I am going to order that rent be paid into court by Thursday the 19th, 1450,
It's
1415,
1415. Yeah.
15, excuse me. And thereafter, if the case remains open, if it's not resolved on the 23rd, then you will be ordered to pay rent into court each month on the 5th in the amount of 1415 until the case is actually resolved. If you fail to make one of those payments, Miss Williams, the landlord can apply for an immediate writ of possession against you. Okay? When you come to court on the 23rd, please make sure to bring printed out copies of any documents that you want the court to consider. So even if you've already uploaded them, it just makes things go much smoother if you have printouts. And bring 3 copies of each document, one for yourself, one for the plaintiff's counsel, and one for the judge. Okay?
May I ask a question?
Of course.
When you say pay into the court, what does that mean?
So I'm going to issue a written order today. You will receive a copy of my order by email, and there are specific instructions about how to pay the rent into court, but it goes into the registry of the court. You do not pay it to the landlord. Do not mail it to the landlord. Do not mail it to the registry of court. I believe you can make an online payment. I think there's a 3% service charge to do that, to pay by credit card or pay online, or you can walk it into the clerk's office, and the address for that will be in the written order.
Okay, thank you
All
for
right.
explaining.
Yep, you're very welcome. All right, so the case has been reset, and we will see you back on the 23rd at 9 a.m. Thank you both. Thank you both. And Miss Williams, you are excused.
Thank you.
Thank you.
12 is a consent.
Mhm.
Writ to issue February 22nd, 11:59 p.m. and a judgment for 27.93 and 76 cents.
All right, Mr. Hendricks, do you agree that you will vacate the property by 11:59 p.m. on February 22nd unless you make some other arrangement with the property?
Yes,
And you're agreeing to have a money judgment entered against you today in the amount of $2,793.76?
yes,
And Mr. Hodges, did you announce court costs on that case?
Plus court costs, yeah.
Okay. And you're also agreeing to pay $54 in court costs, Mr. Hendricks?
yes.
All right. And you understand this is a consent agreement, so it cannot be appealed?
I understand. You said the only thing I can do is make an agreement with them or work it out with the property, right?
Yeah. If
I
they
agree.
take your money, then they can't move forward with the eviction.
Okay.
Okay. And did you enter this agreement freely and voluntarily?
Yes.
All right. Very well. It is now in order of the court. Thank you for being here, and you are free to go.
Thank you.
Thank you.
Bye.
Ms. Porter is here now. Ms. Porter, turn on your camera, please. All right, and your microphone. Please raise your right hand. Do you swear or affirm that the testimony you're about to give is the whole truth under penalty of perjury?
Yes, Your Honor.
Okay, thank you. All right, so Mr. Hodges, just so you're aware, while you were in breakout rooms Daria Porter, they messaged me privately just to say that they had ended the mediation because there was some issue that happened in the mediation. So it sounds like this case needs to be reset for trial. So do you have any announcement other than that?
Request for rent to be paid into court.
All right. Okay. And on this case, what is the monthly rent? What monthly rent are you required to pay, Miss or Mix Porter?
$13.58 a month, thank you.
$13.58 a month. Okay. All right. And Miss Davis, what are we looking at for trial dates in person?
February 23rd at 9 a.m. in courtroom 1200C.
All right. Mix Porter, does that date work for you?
Yes, it does.
Okay. All right. So we're going to go ahead and reset this for trial. You will be required to bring 3 copies of every document that you intend to introduce into evidence, one for yourself, one for the plaintiff, and then one for the judge. Just makes things go a lot faster if things are printed out. I am going to order that you pay $13.58 on or before February 18th into the Registry of Court. Okay. And I will send out a detailed order with explicit instructions about how to do that, where to make the payment, and all of that. Okay. So if you fail to make that payment, then the landlord can apply for an immediate writ of possession against you. If the trial does not get resolved on the 23rd, or the case doesn't get resolved on the 23rd and it gets continued again, my order is going to say that you are required to pay rent into court in the amount of $13.58 every month thereafter, starting in March, and it is due on the 5th of the month. Okay.
Yes, I would like to discuss about how I was served before we continue, if that's available.
All right. So that issue is gonna be left for the trial. And so that issue will be heard because that goes to any defenses that you might have or jurisdiction. Okay.
Okay.
All right.
Judge.
Thank you. We'll see you back on the 23rd. Thanks for your patience this morning.
Thank you. Enjoy the rest of your day.
Thank you too. The whole truth under penalty of perjury.
Yes.
Yes.
All right, then you can put your hands down. Thank you. All right, go ahead, Mr. Hodges.
Number 1,
Mr.
he's going to try
Francisco.
and get it worked out, but that it's a consent writ to issue February 22nd, 11:59 p.m. and a judgment for $82.41.49 plus $54 court costs.
All right, Mr. Francisco, can you turn on your microphone, please?
Yes.
Okay. Do you agree that unless you're able to work something else out with the property, you will vacate by February 22nd at 11:59 p.m.?
Yes.
And you're agreeing to have a money judgment entered against you today in the amount of $8,241.49 plus $54 in court costs?
Yes.
All right. And did you enter this agreement freely and voluntarily?
I did. Yes.
And you understand this is a consent agreement, so it cannot be appealed.
Yes.
All right. Very well. It is now in order of the court. Thank you for being here, and you are free to go.
Thank you, Judge.
Thank you.
Number 2.
All right, Miss Edwards, if you could please turn on your camera. Great. And your microphone. Got it. Go ahead, Mr. Hodges.
2 is a consent pay and stay. Tenant is to pay $6,059.22 in certified funds by 5 p.m. on February 28th. If not, a writ would issue after that date, and the property would be entitled to a judgment for $69.64.72 plus court costs.
All right. Miss Edwards, do you
Yes, ma'am.
agree that you will pay $6,059.22 by 5 p.m. on February 28th in certified funds in order to stay in the property?
Yes, ma'am.
And you understand that if you don't make that payment, the landlord can apply for an immediate writ of possession against you and would have a money judgment in the amount of $6,964.72 plus $54 in court costs? I'm sorry, I didn't hear
Ma'am.
you. You broke up.
Yes. Yes.
Okay. Mr. Hodges, the pay and stay amount, is that through the end of February?
It's an amount the property has agreed to accept. It's not our whole balance, but they've agreed they'll accept it.
Okay, all right, very well. Ms. Edwards, you understand this is a consent agreement, so so it cannot be appealed?
Yes.
And did you enter this agreement freely and voluntarily?
Yes, ma'am.
All right, very well. It is now an order of the court. Thank you for being here, and you are free to go.
Thank you.
Thank you.
Number 3,
Ms. Cooper. Okay, go
Yes,
ahead,
ma'am.
Mr. Hodges.
she's going to try and work it out, but it's a consent writ to issue February 21st, 11:59 p.m. and a judgment for 37.55 and 97 cents plus the court costs, and then we'll set aside the default judgment.
Okay. Okay. All right, Ms. Cooper, are you agreeing today that unless you're able to work something else out with the property, that you will move out by 11:59 p.m. on February 21st?
Yes, ma'am.
Okay, and you're agreeing to a money judgment against you in the amount of $3,755.97 plus $54 in court costs?
Yes, ma'am.
All right, and did you understand that this is a consent agreement, so it cannot be appealed?
Yes.
Did you enter this agreement freely and voluntarily?
Yes.
All right, very well. It is now an order of the court. Thank you for being here. Drive safely.
Thank you. You have a great rest of your day.
Thank you. You too.
Bye-bye.
That's all I have for now.
Okay, thank you. All right, Mr. Young, do you have any announcements?
Yes, Your Honor, I sure do. Starting with position 21.
All right, so Miss Ballard, let me see.
Yes.
All right, I swore you in already, correct?
Yes, ma'am.
Okay, thank you. Go ahead, Mr. Young.
All right, so yes, Ms. Ballard is going to go try to work this out directly with the property. What we've agreed to in the meantime is the writ of possession to issue February 20th at 11:59 p.m. with a judgment calculated through that date of $3,715.63 plus the $54 in court cost and interest at the current legal rate.
All right, Miss Ballard, do you agree that unless you work something else out with the property, you will vacate by February 20th at 11:59 p.m.?
Yes.
And you're agreeing to have a money judgment entered against you in the amount of $3,715.63 plus $54 in court costs?
Yes.
All right, and you understand this is a consent, so it cannot be appealed?
Yes.
Okay, and did you enter this agreement freely and voluntarily?
Yes.
All right, it is now an order of the court. Thank you for being here, and you are free to go.
Thank you.
Thank you.
All right, next after that is position 22.
All right, Ms. Pearson and Mr. Harrison, did I swear you in?
Yes.
Oh, I lost Ms. Pearson.
No.
Okay, and we got you now. Ms. Pearson, did I swear you in? Okay, raise your right hand for me. Do you swear or affirm that the testimony you're about to give is the whole truth under penalty of perjury?
Yes.
Okay, very well. You can put your hand down. All right, go ahead, Mr. Young. What is your announcement?
Okay, so yeah, it sounds like they just plan on moving, but what we've agreed to today is the writ of possession to issue February 20th at 11:59 p.m. Judgment calculated through that date of $3,618.95 plus court costs of $54 and interest at the current legal rate.
All right. Do you all agree that unless you work something else out with the property, you will move out by 11:59 p.m. on February 20th?
Yes.
Yes.
And you're agreeing to have a money judgment entered against you in the amount of $3,618.95 plus $54 in court costs?
Yes.
Yes.
And you understand that this is a consent agreement, so it cannot be appealed?
Yes.
Okay, and did you enter this agreement freely and voluntarily?
Yes.
Yes.
All right, very well. It is now an order of the court. Thank you for being here, and you are free to go.
Okay. Have a great day.
Thank you. Take care.
All right. Next is position 24 with Ms.
Okay.
Hunter.
24, sorry.
Yes.
All right, Miss Hunter, did I swear you in already?
I don't know if you did me. I know you said, but I thought I was on somebody else's when you were swearing in,
Oh,
so I'm
okay.
not sure.
All right, so Miss Dorsey and Miss Hunter, you can both raise your right hands for me. Do you solemnly swear or affirm that the testimony you're about to give is the whole truth under penalty of perjury?
Yes, I do.
Yes.
Okay, thank you. You can put your hands down. All right, Mr. Young, go ahead.
Okay, so yes, with Ms. Hunter, she is just planning on moving as well. What we've agreed to is the writ of possession would issue February 20th at 11:59 p.m. Judgment calculated through that date of $7,546.43 plus 54 in court cost and interest at the current legal rate.
All right, Miss Hunter, are you agreeing that you'll move out by 11:59 p.m. on February 20th?
Yes, ma'am.
And
Yes,
you're
Judge.
agreeing to have a money judgment entered against you in the amount of $7,546.43 plus $54 in court costs?
Yes, Your Honor.
Okay, and you understand this is a consent agreement, so it cannot be appealed?
Yes.
All right. Did you enter this agreement freely and voluntarily?
Yes, I did.
All right, very well. It is now in order of the court. Thank you for being here. I wish you all the best.
Thank you so very much.
Thank you. Take care.
Yes, sir.
All right, position 29 with Miss Dorsey. Go ahead, Mr. Young.
Okay, so yes, Ms. Dorsey does want to go try to work something out with the property, and I want to give her some ample time to do that based on some issues she raised. So what we've agreed to today is that the writ of possession would issue March 4th at 11:59 p.m. With a judgment calculated through that date of $3,089.68 plus court costs of $54 and interest at the current legal rate.
All right, Miss Dorsey, are you agreeing that you'll vacate the property by 11:59 p.m. on March 4th?
Yes, ma'am.
And you're agreeing to have a money judgment against you in the amount of $3,089.68 plus $54 in court costs?
Yes, ma'am.
Okay, and you understand that by entering this consent agreement today that you're essentially waiving any counterclaims that you have against the plaintiff?
Yes.
All right. And did you enter this agreement freely and voluntarily?
Yes.
And you know that it cannot be appealed because it's a consent?
Yes.
All right, very well. It is now in order of the court. Thank you for being here, and you are free to go. So position number 4, there was a consent agreement that y'all entered into on the 23rd of January, correct?
Right.
Okay, and their order was that you would pay $41.2390 by January 30th. Has the landlord accepted that amount?
They did.
Okay, and they're not, it doesn't look like they've proceeded on for an eviction or anything like that. So, has this been resolved?
It's been resolved. For some reason they didn't at first want to follow the court orders, so I went downtown and they told me to fill out an answer to speak with you today, just in case if they didn't want to accept it, but they accepted it.
Okay, all right. So are you dismissing your motion today then?
Yes, ma'am.
Okay, very well. Then I'll go ahead and make a note that your motion is dismissed and you're free to go. I'm glad that things worked out.
Thank you.
All right, take care. You're excused.
Okay.
Okay, number 6.
All right, you announced that there was a motion on this case, but I think you were referring to the other case. Is that
I
correct?
was. I
All
don't
right.
believe there was actually.
Miss Crosby, could you please turn on your microphone and your camera?
Hello.
All right, raise your right hand.
Uh-huh.
Do you swear or affirm that the testimony you're about to give is the whole truth under penalty of perjury?
Yes.
Okay, thank you. You can put your hand down. All right, what's the announcement on this case?
It's a consent pay and stay. Tenant is to pay $65.47.98 in certified funds by 5 p.m. on February 18th. If not, a writ will issue on after the 11:59 p.m. on the 18th, February 18th, and then the property would have a judgment for $47.08 $30 plus $54 court costs.
All right. So, Ms. Crosby, are you agreeing that you will pay $6,547.98 in certified funds by 5 p.m. on February 18th in order to stay in the property?
Yes, ma'am.
And Mr. Hodges, when is that rent and fees through?
I'm not exactly sure. I take it through February.
Through the end of February?
Yes.
Okay. And then, Ms. Crosby, you understand that if you don't make that payment, the landlord can apply for a writ of possession at 11:59 p.m. on that same day, and will have a money judgment against you in the amount of $4,708.30 plus $54 in court costs?
Yes.
And did you enter this agreement freely and voluntarily?
Yes.
All right. And you understand that this is a consent, so it cannot be appealed?
Yes.
All right. Very well. It is now an order of the court. Thank you for being here, and you are free to go.
No problem. Thank you.
Thank you.
Mhm.
Drive safely.
I would actually like to start with position 21 because she's got an important thing to do.
Okay. All right.
Yeah.
So for everyone who is currently present in the courtroom right now, please turn on your microphone and your camera, and I'm going to swear you all in at once. Mr. Ruzan? Oh, no, you don't have to shush. That's okay.
No.
All right. Ms. Bryant Gaither, if you could please turn on your camera and your microphone. All right. Everyone, please raise your right hands. Do you swear or affirm that the testimony you're about to give is the whole truth under penalty of perjury?
Yes.
Yes.
I do.
I do. All right, great. Thank you. Y'all can put your hands down. All right, Miss Brown and that adorable baby. What is your announcement, Mr. Young?
All right. So with Ms. Brown, yes, she is going to go try to work this out directly with the property. What we've agreed to in the meantime is that the writ of possession would issue.
Hold on,
February.
Mr. Young.
Oh, yeah.
Hold on 1 second. Miss Davis, what position is this?
So this will be position 26D02234. On our calendar, she is position 21. On your calendar, she's position 20.
Because I was in a whole nother
okay,
thing
Miss
with
Brown.
other people.
All right,
Yeah.
I got it. I'm so sorry. Okay,
Okay.
Mr. Young, sorry to interrupt you. Go ahead.
No, not at all. We were noticing the numbering issue as well, and we're a little confused, but that's okay. All right. So she is going to go try to work this out with the property. What we've agreed to in the meantime is that the writ of possession would issue February 20th at 11:59 p.m. with a judgment calculated through that date of $3,011 even, plus $54 of court costs and interest at the current legal rate.
All right, Miss Brown, do you agree that unless you make some other arrangement with the landlord, that you will vacate the property by 11:59 p.m. on February 20th?
Understood.
And you're also agreeing to have a money judgment entered against you today in the amount of $3,011 plus $54 in court costs?
Correct.
All right. And you understand this is a consent agreement, so it cannot be appealed.
Yes, ma'am.
All right, very well. And did you enter this agreement freely and voluntarily?
Yes, ma'am.
All right, very well. It is now an order of the court. Thank you for being here, and you are free to go.
Thank you. I'm going to have another grandbaby.
Oh, congratulations.
Oh, congratulations.
Thank you. Thank you.
My
Enjoy
niece
your
is in
day.
labor right now, so I'm waiting.
My daughter's in labor. That's why I'm trying to go. She's in labor
Congrats.
right now.
Congratulations.
Thank you very much. Enjoy the rest of your day.
Best wishes. All right, go ahead,
Thank you.
Mr. Young.
Same for you.
It sounds like y'all were not able to work something out, and Mr. Young is asking for me to grant him judgment on the pleading. So I need to see if you raise your defense. Hold on 1 second. Hold on 1 second, please.
I don't like that. That looks nice with the real. That's okay. I know she lies to me.
All right, Mr. Rosen, I read your answer. It does not sound like you have raised any legal defenses based on your answer.
I didn't get an opportunity really. I mean, between you and him explaining what would be acceptable and what would not, all of the evidence that I had would have been null and void to start with. You would not have listened to what I brought you. Because it comes down to one key factor, and that is money. And right now, I don't have money, and I'm not going to have it within 7 days. I explained to him that I have all the everything to get by these last 2 months, take care of these people and other people who I owe money to. Now it's time I've got to pay back the people who owe me money to begin with. You understand? That's the way it goes.
Yeah,
But that does not mean I don't want to deal. I do want to deal. I do want to deal.
Okay, sir. Well, it does not sound like you have a legal defense under Georgia law. Therefore,
Well, suppose you tell me what is one then. If I don't have a legal defense, suppose you tell me what is a legal defense.
unfortunately,
Okay,
sir, I cannot give you legal advice because I'm here as a judge today, not as an
All right.
attorney. So you may need to consult with a private attorney or Atlanta Legal Aid or DeKalb Pro Bono if you're unable to afford an attorney. But we're here today on the plaintiff's request for writ of possession. It sounds like, according to your answer, you have not raised a legal defense. Inability to pay is not a legal defense under Georgia law. Okay, and you've just admitted that you don't have the money. So if you'd like another opportunity to talk with Mr. Young, I'm happy to give you that opportunity. But if not, I'm going to grant his request for writ of possession in 7 days.
I'll deal.
I'm sorry?
I'll deal. I will
right.
deal.
So you'd like an opportunity to speak with Mr. Young
Yes.
again? All right, that's fine. I can put y'all back in a breakout room.
Thank you, Your Honor.
For this case, Your Honor, Joy Davidson is the only party to the lease and was the tenant listed per the filing.
Okay.
And she's not present. I understand that he has tried to get her to log on. I'm not sure what was going on there, but she couldn't get on for some reason. I don't
Mr.
have any authority.
Yes.
Where is Miss Davidson?
She's at work. She's
Okay.
at work.
All right. Well, it looks like she filed the answer in this case, but let me confirm. Yeah, so she filed the answer. Without her being here, unfortunately, do you live in the property?
Yes, she's the one who gave me the link and told me to assist it because she wouldn't be able to.
Mm-hmm. Well, I don't think that Miss Lewis is going to be able to negotiate with you since you're not on the lease. So Miss Lewis, how would you like to proceed?
Your Honor, I would seek a default judgment. I don't mind giving 7 days instead of an immediate writ.
Okay. So
So
what would
yeah, so she said she will go and request for another course for another day as possible so she can possibly join and then attend it.
I mean, that would have been something to raise with us a couple of hours ago, I think. You know, she knew that the hearing was today.
Yes, me and the lawyer have spoken, and she's the one who told me to try to reach her, which I did. I also tried to let Mrs. Clerk know about that. So I've been waiting for hours to actually give that information.
All right. Well, unfortunately, it's, you know, she's not here. She's the one on the lease. You did not file an answer. So I think that Miss Lewis is going to move forward. I'm going to deny your request for a continuance today. With the, I guess, the caveat that if we do continue it, I would order you to pay rent into court, but she's not here, so I don't think I can do that either. Well, I probably can. So thoughts, Miss Lewis?
Your Honor, I understand the circumstances, but I would object to the rent to pay into the court just because she isn't here and she was aware it is a default. I'm willing to give him 7 days or give them 7 days.
Mhm.
If they could possibly work something out with the property directly.
Okay.
Yeah, we've been talking with the property and we told them about that.
All right. Well, unfortunately, Mr. Niodogo, Miss Davidson is not here. She was not able to appear. She did not request a continuance in advance of the hearing. So I'm going to go ahead and grant Miss Lewis's request for a default judgment. So the writ will issue on February 18th. And the money judgment in the amount of, so $23.75 for January. $1,526.79 for February through February 18th, and then a late fee of $237.50. So a total of $4,139.29. So, and are you seeking court costs, Miss Lewis?
No, Your Honor.
Okay. All right. So, Mr. Niodogo, I'm going to enter that order. It's going to be a default judgment against Miss Davidson. The order will say that if y'all have not moved out by the 18th, then the landlord can apply for a writ of possession, and they will get a money judgment today in the amount of $4,139.29. Now, hopefully y'all can work something out directly with the property. If they accept any money from you, then they cannot move forward with the eviction, okay?
Okay, so if we pay the full amount by then,
Well, no, not necessarily, because that amount is only through February 18th. You probably owe all the way through the month.
yes,
If you want to stay, I mean, I don't have a crystal ball. I can't tell you for sure, but I'm guessing that they will want all of the rent for February, along
correct.
with the back rent and other fees and stuff like that. So
Yes,
it likely would be more.
yes, I'm aware of that. If 5,400, nah, I was saying that if the full payment is made by then, what would be the next?
So if nothing, I mean, unless you make a payment and any amount, even $1 or $2, if the landlord accepts it, they cannot move forward with the eviction.
Okay,
But they don't have to accept any money from you.
okay,
Right? And there will still be a money judgment against you in the amount of $4,139.29.
okay,
Okay. If you have any more questions than that, I recommend that you speak with an attorney who can maybe explain it a little more or discuss your options with you.
okay.
All right. I wish you all the best of luck. Thank you, sir.
Thank you. So I can leave?
You are free to go. Thank you.
Thank you. Have a blessed day.